everybody. Welcome to Truth and Transparency. We're going to jump right into it. Karen Reed, trial watchers. We're right around the corner. So next week, we'll be having a hearing on all motions in limine and the final trial conference. April 1st. Can you believe it? Fool's Day. You're all fools for this one. We will have our trial. Again, come on in, slap that thumbs up. Let's do it. Motion in limines continue. Just to make sure you guys know what we've gone through or what's out there. So defendant's motion in limine to present the demonstrative exhibit. We went over that. Defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial prior bad character. Defendant's motion to impound portions of defendant's motion in limine to exclude certain witnesses before and after testimony. We know what that's about. Little did an affidavit on it. Defendant's motion in limine to exclude certain witnesses before and after testimony. Same ballpark. Defendant's motion in limine to exclude certain witnesses before and after. This is now the redacted version. Defendant's motion in limine for the view of the lawn. Defendant's motion in limine to prohibit testimony regarding funds paid to experts for the purposes of the voir dire, that's for ARCA. Defendant's motion for attorney to them to conduct a voir dire of the jurors and ask them certain questions. Defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having any contact with witnesses once they've taken the stand. And that's where we'll pick up. Right here. So, unbelievable here, guys, that Karen Reed is asking for the court to prohibit the Commonwealth and its agents, including but not limited to the prosecutors, law enforcement, and victim witness advocates, from speaking with or having any contact with any witnesses once the witness has taken the stand. During Ms. Reed's first trial, the defense learned that the Commonwealth was having improper conversations with witnesses while they were in the middle of their testimony. For example, on cross-examination, Brian Albert indicated that he had spoken with Assistant District Attorney Adam Lally over the lunch hour while the court was in recess during the middle of his testimony. You guys. When asked what they had discussed, he initially denied speaking about the substance of his testimony, but then later admitted that ADA Lally had discussed some of the topics he wanted to ask him on redirect. He maybe mentioned one thing. He may ask me, he was going to ask me about what happened at the house in the morning. You know, some of the questions on redirect. That's all. End quote. So Ms. Reed is saying that we would like nobody. Ms. Reed states that the court is and has discretion to prohibit this communication and therefore asks that it happens. Next up, defendant's motion to impound, defendant's motion in limine, excluding irrelevant and inadmissible prejudicial evidence regarding alleged harassment and or intimidation of witnesses. So now Karen Reed says, and respectfully requests that we have an order impounding defendant's motion in limine to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and or intimidation. What do you guys think about that? So again, good morning, everybody. Welcome. Come on in. Come one, come all. Karen Reed, she sucks, and the Bimbos and Lemonade. Can you guys believe that that Alan Jackson's team had to waste precious time on writing a motion to keep out somebody's opinion that Karen Reed sucks? It's pretty wild. It's pretty wild. So, next up, defendant's motion in limine to exclude the blood alcohol. So Karen Reed saying this is so freaking bad about, like, Alan Jackson broke it down trial 1. Do you know what that would even equate? And was doing math with the guy up on the stand. So we want to say, Karen Reed saying, hey, we want to exclude evidence of this plasma ethanol concentration test performed by Good Samaritan Hospital at 9:08 a.m. on January 29, 2022. So when people ask, did Karen Reed go to the hospital that morning? This should help that. Yes, she did. Ms. Reed necessarily moves to exclude the blood concentration conversion performed by the Massachusetts State Police, as well as the corresponding retrograde extrapolation analysis. It's wild. As grounds for this motion, Ms. Reed states that, as acknowledged by MSP forensic scientist Nicholas Roberts, I really liked him, by the way. I thought he was just, you could tell he had nothing to do with any of this shit. The ethanol results used in the reports was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory, and therefore the reports do not fall under the laboratory scope of accreditation. So, and if you look at the report, see the exhibit, there it is. Also, Exhibit B from June 6, 2022, that's the extrapolation report. Since the Commonwealth cannot establish the blood test results administered by Good Samaritan Medical Center is reliable for the purpose of a criminal prosecution, the ethanol concentration results and the corresponding blood conversion and retrograde application, which derive their results from the initial result, should be excluded as unreliable and the product of reliable principle and methods. See this. The other thing I thought was weird is nobody testified who took Karen Reed's blood in the first trial. I mean, who did it? You guys do know that nobody testified that they were the actual person that took her blood. So I thought that was interesting. Here's the factual background on that. On January 29, 2022, around 7:26 a.m., Ms. Reed was admitted. And so I used this to then work my way back to see when she would have left 34 Fairview. That's when she would have left 34 Fairview to be able to, see when she was admitted. So, because I was really concerned about the whole Carrie Roberts thing and crap like that. My audio is muffled. Is it? Oh, it shouldn't be. So a vampire took her blood. Oh, shit. Yeah. Here we go. So she gets admitted at 7:26 a.m. As a result of the acute grief reaction she experienced after learning that her then boyfriend, John O'Keefe, had passed away. In addition to evaluating her, the hospital performed blood work and a urine drug test, which included tests for the presence of drugs and alcohol. Miss Reed tested negative for any drugs for which the hospital screened. The hospital, however, recorded an alcohol level in Miss Reed's blood of 93 mg. Using the value from the test conducted by the hospital and without ever having applied for a warrant to themselves test Miss Reed's blood, as would be the normal course in a prosecution involving any aggravated form of operating under the influence, Massachusetts State Police performed a conversion of the reported 93 milligrams resulted to a blood alcohol concentration of 0.078 to 0.083, based on 3 different conversion factors on May 4th, 2022. Do you guys know how high that is? She'd be dead. Yeah. I guess I'm okay. So, is it a Massachusetts thing? This seems like it would have been something that would have been suppressed versus having like a suppression hearing. But I guess they're just doing their motion lemony. They're just doing it all with like as like a suppression hearing as well. Is that normal in Massachusetts, or was it just, you know, with this case and all the crazy stuff that's been going on? But so something that came up in the first trial is that they then did, because based on when Miss Reed was tested, okay, they then did a time interval of 8.5 hours with an additional 2 hours allowance from the time of 12:45 a.m., the time of the alleged incident, in an attempt to, quote unquote, account for the uncertainties associated with the drinking history of the subject prior to the time interval, end quote. Her calculations determined that Miss Reed's blood alcohol could have been between 0.14 and 0.28 at around 12:45. This calculation assumes that the subject's BAC had peaked at or prior to the start of the time interval, indicating that the subject had consumed no ethanol 0.5 to 1.5 hours before the time interval. So I think this is all just like, it's a, you're just assuming too much. You're taking a lot of assumptions here. This range differs from the range testified to by the forensic scientist used by the Commonwealth at the first trial, Nicholas Roberts, again, who I liked, who indicated that the range would have been between 0.13 and 2.29%. This is their argument. Because both the initial conversion report and the subsequent retrograde analysis are based on blood tests about which the parties lack essential information, including testing procedures. Interesting. The blood test results should be excluded. Extrapolation is a quote unquote a mathematical calculation used to estimate a person's blood level by working backwards from the time the blood alcohol test was taken, taking into consideration rates of both absorption and excretion. What the fuck? The SJC, the Supreme Court, has held that, generally speaking, retrograde extrapolation analysis meets the Dauber-Lanning standards for admissibility. So it's admissible. Breathalyzer test results are generally admissible without the need for, so then what the fuck, without the need for expert testimony when taken with any reasonable time. I want to see if it has to do with the time that they're arguing it should be. Here's a new case. Just last year, the Supreme Court addressed the issue of defendants' consent to a blood test in a prosecution for simple and aggravated forms of OUI. In comparison cases, the Commonwealth, Cappellucci, Commonwealth, Zucchino. The court held that the constant requirement of MGL only applies in prosecutions for simple OUI under GL, rather than to have any of the aggravated forms of OUI. Accordingly, whether Ms. Reed consented to the blood alcohol test or not is not at issue here. What is at issue, however, so this is their issue, is that the parties lack essential information about how Good Samaritan Medical Center drew and tested Ms. Reed's blood. And I'm telling you, it's because no one testified about it. It is standard practice in prosecutions for OUI and its aggravated forms for police to request and be granted a warrant so that they can themselves test a defendant's blood through a certified analysis in accordance with the provisions. While these requirements pertain only to analysis working for the state police and not to hospital personnel, they are in place to ensure that blood testing for ethanol undergoes a standardized, reliable, repeatable procedure. Now, the Commonwealth is going to have to fight this hard because this is their whole case with the charges. You understand? Like, this is a big part. So this is something that you want to definitely give time to if you're Alan Jackson and the defense. If that gets tossed and it's not in play for, trial 2.0, that's a huge win for Karen Reed. So this is a really, really important motion limiting. So regardless, the defense should not have to guess. The Commonwealth should have, at minimum, provided documentation from the hospital regarding how the alcohol test results were obtained. Exactly. Because I'm telling you, nobody testified to this. Through what procedure? By whom? You should not be able to testify to anybody's report except your own. Oh, wow. Sorry, I had to get some water there. I love it. I think people think because I put she sucks, people think that this is about that Karen Reed sucks. My title, people think that I'm saying that Karen Reed sucks. What a bunch of fucking nobodies that know this case then. I mean, how could you be so diehard Karen Reed and not know that the she sucks is what these fucking bimbos said? Isn't that wild? So, and what matter of testing used? So, that just tells me you don't know dick and put a dick in it. Good morning, ladies and gentlemen of the jury. I want bimbos. Bimbos suck. She sucks. I just love how Little put that. That was just hilarious, and that's going down as one of my favorites. But absent this information, the Commonwealth is unable to establish the reliability of this initial result on its face. In light of the fact that Massachusetts State Police, Mr. Roberts, and Miss Knowles, Beyonce's sister, each separately acknowledged in their respective reports that the serum plasma ethanol concentration test does not meet the accreditation standards for reliability outlined in 501 CMR. We know with certainty that the serum plasma ethanol concentration test was at very least conducted according to an entirely different scientific protocol. This is such an important motion. The defense does not take issue with the general exception and accepted scientific practice of retrograde extrapolation itself, but rather with the data upon which it was based. The data. Without reliable foundation information about the initial result, than the serum plasma conversion to blood ethanol concentration. It's like doing a math problem and you fucking don't have the right numbers. I mean, you're going to get the wrong results. More precisely, the Commonwealth has not provided any information about the initial result from the hospital that would indicate that the subsequent analysis by Mr. Roberts and or Ms. Knowles are accurate. Where they don't have the initial results from the hospital. Instead, 3 parties involved in the back blood alcohol test have expressly disclaimed the legal veracity of these results. The analysis of Miss Reed's blood was not in fact made, at least not completely, by the chemist who signed and sworn the certificate. You guys, this is crazy. This is nuts. At least completely by the chemist who signed and swore. I remember that part. And is admitted to in the reports by the Massachusetts State Police, Mr. Roberts and Ms. Knowles. And this is admitted to. In his testimony at trial, Mr. Roberts admitted that while the standard lab testing procedures is to conduct 2 separate tests within the laboratory, with Ms. Reed's sample, he conducted no testing himself and merely assumed that the hospital's tests were accurate. This is getting tossed. This is getting fucking tossed. What's up, allegedly LB? Welcome. This should get tossed. This needs to get tossed. This is huge, though, for Karen Reed, this motion. Okay? Because if the jury doesn't hear anything about this blood alcohol level and it being over the limit, then you can just take your, we call it an OVI here. You can just take your DUI and straight flush it. Okay. So think about that. This is a huge motion. This needs to be suppressed. I think it's also a big waste of time. So both of their analysis were conducted with data that they did not themselves collect. Mr. Roberts himself confirmed that an unreliable base for calculations like we have here is a serious problem for the reliability of the extrapolation result. You do not have to base the extrapolation on calculation on good. Your starting blocks have to be good. So you have to know the time in which the blood was drawn, the time of the incident, and essentially what your value was for your value. All 3 of Mr. Roberts' key factors are not clearly known. The common factor between the 2 authorities is treatment. Miss Reed's visit to Good Samaritan Medical Center on January 29, 2022, and the records produced therefrom were explicitly not part of any process of the administration of medical treatment. So talking about admissibility, they're using this as like basically a motion to suppress. So what do you guys think? I'm going to be doing a Excel spreadsheet for people to put yeses and nos on what they think Bev's going to click on. So that was a big one, keeping out the sample. Motion to impound defense motion in limine to exclude witnesses' prior criminal history. So now comes Karen Reed, and she moves for an order impounding defendant's motion in limine to exclude witnesses' prior criminal history. Good cause exists for the impoundment of this motion and supporting exhibit because it contains references to confidential arrest records. Now, on the opposite side there, the Commonwealth is seeking to keep out people's prior bad acts. I printed that one twice. All right. So the Commonwealth moves. So we're going to move over here to the Commonwealth here for a second. And again, this is all trying to figure out what the rules are going to be, what's in, what's out, what you're allowed to talk about, what you're not allowed to talk about. So the Commonwealth's motion in limine for sequestration order and for relief. So right here, this is basically these people right here can be in there every single day, and they don't have to be part of the sequestration order. This happened last time. So Janet, Bill, Nate, Peggy, the victims, nephew, niece, and then Paul and Aaron. So Paul and Aaron, maybe they made up. They will be in there. Commonwealth, motion limine to allow in-court identification. Well, what's in-court identification? The Commonwealth moves in limine to allow an in-court identification of the defendant. And so, hey, that's, I can point at her and I can say that's her. That's her. That's Karen Reed. That's who I saw that night. That type of shit. Next up, Commonwealth motion limine to preclude reference to and redact the manner of death contained on the victim's death certificate. Interesting. Great question there. Olivia Rose says, what about Paul's girlfriend? Can they all sit together? I love a good throuple, so throw them in there. The Commonwealth moves in accordance with the settled practice that the death certificate be redacted for the means and manner of death. We have stated that with respect to the admission of death certificates, the better practice is to redact the manner of death, such as the words homicide, suicide, accident. In a criminal trial, excluding from the death certificate the words homicide, suicide, accident, or in this case, undetermined, is the better and safer course. Undetermined. They want to cover that up. Wow. Wouldn't you want to know that if you were a juror? Where the defendant does not dispute the validity of the death certificate or the fact that John O'Keefe is dead, the question of liability is left solely to the trial jury. For the above reasons, the Commonwealth, as this court, preclude any reference to and to redact the manner of death. Isn't that kind of wild, though? Because they have the option to pick this, or this. Undetermined. What do you think is going to happen with that one? I don't think that that's going to fly. My take. Karen Reed, Commonwealth's motion in limine of intent to obtain court records of potential jurors. So I want to know what this was even about. So prior to swearing in the jury, the Commonwealth moves in limine for the opportunity to inquire into the criminal records of jurors to determine whether they are qualified to serve. Inquiring into the criminal records of jurors in a criminal case for the purpose of determining their qualifications to serve their impartiality fits squarely with the criminal justice duties of prosecutors and is permitted by the core statute. So, what do you think? Sure. They want to make sure that nobody's got DUI on there. That's what I think. They want to exclude DUI award winners. That's what I think. That's my take. A juror who purposely conceals their criminal history cannot be found to be impartial or able to follow the court's instructions. Well, why would they be lying about that, you know? So I guess maybe what it is that, listen, we're not saying that we're going to exclude people, but we want to know, that way we can just know if they're lying or not about it. So next up, Commonwealth's motion limine to preclude reference to any alleged bad character and any prior misconduct of the victim or any witness. Now, this is a big one for the Colin Alberts of the world. So now the Commonwealth, and now comes the Commonwealth and moves this court to order counsel to refrain from making any reference before the jury of any alleged bad character or alleged misconduct of the victim or any witness without prior court permission. Specifically, the defense has made allegations about civilian witnesses and law enforcement witnesses, and the public has been saturated with unfounded claims. Well, I would think videos that's not unfounded, of Colin fighting. At the previous trial, the defense lodged a slew of claims of alleged bad acts of witnesses. Indeed, the defense has engaged in a comprehensive campaign to inundate the public with its claims and has repeatedly declared or implied that the Commonwealth, the prosecutor, the court, trial court employees, and witnesses are corrupt, declaring that virtually every civilian witness, police officer, and first responder was complicit in a cover-up of evidence, and implying that nearly every witness is a liar. Hanks just put it out there. Such allegations have no foundation nor bearing on any issue in this case and would constitute impermissible bad character evidence, whether during the opening statement, during cross-examination, or of any Commonwealth witness, during direct examination of the defendant's witnesses, or during closing arguments. Defense counsel should be restrained from making such references unless obtaining prior court approval. A judge may appropriately exclude evidence that is introduced merely to show the bad character of a witness. Further, evidence of prior misconduct may not be used to impeach a witness's credibility except by production of records of criminal convictions pursuant to the limitations and requirements. And the defense went and grabbed all those. So a trial judge has the sound discretion to determine whether prior bad act evidence is relevant and whether the probative value of such evidence is outweighed by its prejudicial effect. I mean, I think that impeaching a witness, though, from trial one, what they were allowed to talk about, if we've uncovered things from trial one to trial two that can impeach them, okay, then you're going to have to allow that. I mean, I'm sorry, but that's my take on it. Happy Proctor Day, y'all. Yes, Proctor is seeing the board again today. Proctor's seeing the trial board, or that's going to be coming up here in a second about Proctor. So it'll be interesting how this one plays out. Well, Commonwealth's motion for offer of proof prior to defendant calling or summoning the Norfolk District Attorney and victim witness advocate as witnesses, and request for an order that neither is subject to a sequestration order. So Karen Reed's team is going to try to call, or if they try to call, here's what the the Commonwealth wants. Now comes the Commonwealth and moves this court order, or asks that this court order the defendant make a satisfactory offer of proof prior to calling in or summoning Norfolk District Attorney Michael Morrissey and victim witness advocate Stephen Nelson. Well, you guys know why Stephen Nelson would need to be called, right? Because Stephen Nelson met with Jennifer McCabe, Matt McCabe, and for a finding that the district attorney and Mr. Nelson are not subject to any order of sequestration. On March 6, 2025, the defendant listed both the district attorney and the victim witness advocate as potential defense witnesses. When a defendant resorts to the extraordinary means of calling a prosecutor as a witness, he must make a satisfactory offer of proof as to the need or testimony from the prosecutor. Now, I would think that there's a substantial amount of proof now once Proctor has testified, okay? Because of the DA's statements that Proctor didn't know anybody, had no ties to anybody, all that shit, okay? Once Proctor would have testified, that goes out the window, meaning everything that the DA said was false as fuck. What do you guys think about that? Generally, witness has a burden of showing why the subpoena should be or should not be enforced. A prosecutor should be called only when there is a showing that the prosecutor's testimony is relevant, material, and not cumulative. District attorney is the elected official of the Norfolk District, a position he was first elected in 2010. As such, he is the elected advocate of the people and the chief law enforcement officer for the district. District attorney is the people's elected advocate for a broad spectrum of social interests. Mr. Nelson is an employee of the Norfolk District Attorney Office and is the assigned victim witness advocate in this case and has been assigned to the case since January 2022. Blah, blah, blah. Neither the district attorney nor the advocate were witnesses to the charges before this court. The extent the defendant may want to impeach proposed Commonwealth witnesses as to statements, the defendant has not shown the absence of alternative sources of said purported information. So here, Hank is getting in front of it. Further, to the extent the defendant is seeking either the district attorney or the advocate's opinions or observations regarding witnesses' mental impressions, research, or evaluation of the evidence for the Norfolk County case, such areas of inquiry reflect privileged work product. Therefore, the Norfolk County District Attorney's Office respectfully requests that this court order that prior to calling or summoning the district attorney or the advocate, the defendant make a satisfactory offer of proof before this court, and that this order find that they are not subject to any sequestration. They did this in trial one. It'll be interesting. Commonwealth's motion in limine requesting use of chalks and directing both parties to provide visual presentation and chalk prior to using. So now comes the Commonwealth and respectfully requests that the court allow the Commonwealth to utilize computer-assisted technology, AI, possibly. So the proponent may be uses a summary, a chart, or the like to provide improved content of voluminous writings or records that cannot be conveniently examined in court. Specifically, the Commonwealth seeks to use the following. Here we go. Well, surveillance videos, photographs, videos from the crash reconstruction. They have a reconstruction. Videos from the reconstruction at One Meadows. Diagram of scene and roadway. And diagrams and digital forensic extraction reports. Oh, I know what he wants with this. They want to do a Cellbrite demonstration to be projected onto a screen by a computer. I can't believe that you have to ask for permission to do this. These would be enlarged photographs and clearly admissible if they are sufficiently verified and are fair representations of the subject matter. A trial judge has considerable discretion regarding the admission of chalks. Well, so he wants them, they want them, so why wouldn't it be allowed? The Commonwealth asserts that the technology will be used to merely display admissible evidence. So they want to use Hector. Hector can display it. Or to assist the jury in understanding certain testimony. So just like the defense wants to use for Hanley's reconstruction of the taillight and where all the pieces came from. So I'm just shocked that they didn't stipulate to this. So something they must not want in. And I'm guessing it's going to be stuff to do with this reconstruction stuff. So thoughts on that? I would think that anything that you put up on the screen, I'd be asking that the jury get in a booklet, that the jury gets a booklet. Listen to what that juror said. Like, they didn't organize their notes appropriately. So a booklet of demos. That's what I would add in there. Next up. Now comes the Commonwealth and respectfully request this court preclude the defendant from raising a third-party call for defense. We're going to spend some time on this. Preclude third party. Well, guess what? If I didn't do it and y'all are saying it's murder, then somebody did it. Who did it? Okay. I think this is a bullshit. I think that this should never even be, I should be able to say that fucking Peter Pan did it if I want to say Peter Pan did it. And then the jury can laugh at me. Okay. But if I'm saying that I didn't do it, then somebody else clearly had to do it, right? Or we're going to show you that it was an accident of some other sort. Now comes the Commonwealth and respectfully request this court preclude the defendant from raising a third-party call for defense. The defense position has chronically been fluid and unsubstantiated. Now we get into Lana land over here. We have Higgins on the phone now. So that's just one thing that's new. The defense claims, or the defense claim has been nebulous from its origin. Karen, just to be clear, you didn't do it. We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know. After the first trial, the defense position began transformation. Well, like anything with getting more information, transformation is fine. And it should be expected. Because if things are going to point you in a different direction, then you should be moving in a different direction. It's like an investigation, you dumbasses. All right? Something that cops struggle with. Follow the evidence. You guys piecemeal this shit. You guys broke us stuff off. You didn't allow us to get the phones when we had asked to get those motherfuckers' phones. All right? What we think happened has nothing to do with how we plan to strategize for our case. That's two totally different things. And Hank Brennan knows that as a defense attorney. Land, I need dual citizenship. We're going to retool everything. And maybe some things will stay, some more, but we're going to shuffle a lot of things around. Again, he is literally taking these interviews. And I told you how I feel about these interviews. I'm not a fan of them. Because I am of the firm belief of this, you guys. In this world, whatever you say and do will be used against you. 100,000,000%, no matter what. No matter what. Everybody will find a way in situations like this that whatever you say and do, they will use it against you. And so that's, that whole right of like you have the right to remain silent. Why do you think that we have that right? It's powerful. Just like a dealer having to stay on soft 17, so powerful. It's like in our favor if you're playing for big money. If you're playing for $5 a hand, fuck cares. But why any of this has anything to do with this, to me, is just propaganda. Most recently, in its Fox 25 sit-down, the defense responded to the question, in your opinion, there have been a few names that have surfaced in this third-party culpability theory. Who do you think, if John was beaten up and attacked in that house, who did it? Defense counsel uttered, we don't know. The defendant quickly echoed, we don't know. Counsel furthered, and it's not for us to know. Somebody other than Karen is responsible for the killing of John. But who it was specifically? Others know, and they're not talking. And the others that know, when they're saying that, others know, I think according to the defense, they're talking about the people that were at 34 Fairview. But look at how Hank's trying to use this to say, like, you are saying you don't know. So how are you going to come in here and do a third-party culpability when I have you quoted saying that you don't know who did this? Like, I don't like it. It sucks. The evolving responses have facilitated from an unidentified certain villain to not knowing who is responsible and having been the hallmark of the defense's third-party culpability claims since its inception. All Alan Jackson's going to have to say, in my opinion, is that we said we don't know because we're not giving out our trial strategy. Right? You can try to swing it that way. Or we weren't trying to make extrajudicial statement. I mean, the stuff that we are going to be using was under protective order. I mean, they're going to have to say something about this. So the defense is not entitled to simply engage in torched earth tactics, making baseless claims about witnesses without any evidentiary foundation. That's a stretch there, Hinky. Prior to the first trial, the court made rulings relative to the defense's third-party culpability claims. You got to stick with the Google search, and you just stick with the McCabe family. the Mick family. I'm not going to do that now. I am going to give you a chance to develop it through relevant, competent, and admissible evidence, but you cannot open on it, so that is my ruling on that. So here we go. Prior to the first trial, the court made rulings relative to the defense's third-party culprit claim, so this is back in trial 1. The court ordered, based on the offer of proof on Friday, I am well within my right, pursuant to the case law, to exclude the third-party culpability defense. I'm not going to do that now. I am going to give you a chance to develop it through relevant, competent, and admissible evidence, but you cannot open on it. So that is my ruling on that. So what has changed? Hank is basically saying, so what has changed? So at the very least, this is where Hank's saying, like, this is where it should be at the very least, is that they can't open with it. Unless, what do you think the defense can say that? So think about that. Despite the court's clear ruling, the defense launched into its third-party claims from the beginning of its opening statement. Karen Reed was framed. Her car never struck John O'Keefe. So she did not cause his death, and that means that somebody else did. Followed by, because the Alberts were involved and because they had close connections to the investigators in this case, Karen Reed was framed for a murder she did not commit. The evidence identifying or establishing a third-party culprit was never forthcoming throughout the trial, and to this day continues to be non-existent. So, interesting. Let's say that right out the gate, like basically, hey, Bev, opening statement. We can't have this. You allowed it. The Massachusetts Guide to Evidence provides that evidence that a third party committed the crime charged against the defendant or had the motive, intent, and opportunity to commit the crime is admissible, provided that the evidence has substantial probative value. Google, and guess what, guys? Ready? Ding, ding, ding. John isn't on the lawn by all accounts of witnesses. The Commonwealth called in trial 1 between 12:30 a.m. and 6 a.m. That's how you get it in. John isn't on the lawn by all accounts of witnesses that were called in trial 1. Okay. Now we have their testimony. So then the question is where was John? Where's the victim? The victim, hello. Where the Commonwealth has their victim unaccounted for from 12:30 until 6. You understand that? He's missing. He is missing. Where is John? That's what these shirts should be saying. Where was John? Where is John? This is how you get third party in. After 3 years, the defendant has yet to provide any evidence as to whom they suggest is the third-party culprit responsible for the victim's death or any evidence of alternative circumstances that would have caused the victim's death. The absence of an evidentiary basis to support a third-party culprit defense was clear before the start of the first trial. So what would you do? I mean, this is a big thing. You know, if you're going to listen to what the juror was saying, and that, go listen to that interview with Turtle Boy. I'm telling you, that juror was invaluable to Karen Reed's defense. Invaluable. To accept the defendant's third-party culprit defense, the court would have to find the defendant demonstrated that, quote-unquote, the acts of the other person are so closely connected in point of the time and method of operation as to cast doubt upon the identification of the defendant as the person who committed the crime. Higgins, Matt, this is what they have. To raise a third-party culprit defense to one charge that is closely intertwined with the other charge would pose a real threat of prejudice by confusing jurors and diverting their attention to lowly collateral matters involving persons not on trial. We're going to develop our third party through experts, right? Expert testimony that the car isn't the murder weapon. So if the car isn't the murder weapon, then what caused the gash to John O'Keefe's top of his head, right? Get the prosecution off the fact that the car is the murder weapon. So that would be number one, is the murder weapon. This is not the car. Time of the crime. Karen left at 12:30 p.m. to be on the Wi-Fi at 12:36 a.m. or a.m. rather. So the murder weapon is not the car. The time of the crime is after Karen left because she's on the Wi-Fi, right? And all the witnesses not on lawn. And then you have the Nagels and Richie, who were right there. They would have witnessed Karen Reed hitting him. Then when you want to talk about when you have to meet this standard, which is motive, means, opportunity. They had the opportunity. Higgins had the motive. Additionally, hearsay offered for the truth of the matter asserted that a third party is the true culprit, and notwithstanding a hearsay exception, may be admitted only if In the judge's discretion, the evidence is relevant. It will not tend to prejudice or confuse the jury. What are they planning on bringing as hearsay? Interesting. Hank has a feeling. This court has discretion to rule in advance of trial whether the defendant has made an adequate showing that potential culprits were connected to the crime. Well, who had access to John? Only those people, right? John didn't have a vehicle on him, right? So where could he have truly gone? Logic is either he got into one of those vehicles that were there or he went to that house. That's all that's logical. But it'll be interesting how because Hank's way better of an attorney than Lally is. Hank's going to be that guy that's going to be objecting during Alan Jackson's opening statements or United's, whoever is going to be giving it. Like if they're not allowed to use third party, and like they need to be prepared on their opening statement. Just saying. This motion in limine is going to be dragged down. It's going to be a fight in there. All right, so 100%. 100%. I just think that it can be open beforehand, but your like it wouldn't change from trial one either. If you say, hey, obviously during trial one we didn't know what people were going to say, but now that we have everyone's testimony here is none of these people saw him on the lawn. He's unaccounted for from this time to this time. So clearly somebody other than Karen Reed did it because he wasn't there in the spot where they found him the next morning. And I would twist it. I would turn it back on the Commonwealth and say, now, unless you're going to sit here and tell me that we're not supposed to believe that all the Commonwealth's witnesses are lying, all right, I would just put it on them. All your witnesses say that John O'Keefe was not there. Was not there. Was not there. Pound it. All right, so Commonwealth is coming out and saying, hey, guess what, guys? We intend to call digital forensic examiner Jessica Hyde and Ian Whiffen again as expert witnesses in its case in chief. The Commonwealth respectfully requests that during Mr. Whiffen's expert testimony, the court allow him to conduct a courtroom demonstration of how data was stored within Jennifer McCabe's cell phone. This is interesting to me. Why are you even going this route? I personally thought that he was going to try to get away from all of this. But if Jennifer McCabe's phone is so important and you're going to do all of this, this is like you're bringing it in. This is opening the door. Why wouldn't you use those people as rebuttal witnesses? Do you understand? So, Justin, Hanks, trust me, way better than Lally. Way better. Doesn't mean, he's just as if not more annoying, okay? He's a sleazeball, you guys, but he's not a fucking dummy. He's not a dummy. He knows tricks of the trade, and I'm telling you, but we're going to get the best version of Alan Jackson because of it. It's like an athlete. When you go up against a shitty-ass team and you're a stud athlete, you can't really see all that person as an athlete can do. When you put somebody in a game where it's a game, then that athlete's going to shine. So we're going to get the best version of Alan Jackson because of Hank. But I believe that this opens the door by even bringing up her cell phone. So I thought Hanks is going to try to get away from this whole thing. He's coming with it. So Mr. Whiffen is the senior. We all know this. The Cellbrite software allows an examiner to parse the layers of data through. We all know this. And Jessica Hyde will use a courtroom demonstration to show jurors information and data on both Jennifer McCabe's and John O'Keefe's phones to explain concepts and to illustrate particularly information of importance about each respective phone's data. Jennifer McCabe provided her cell phone to law enforcement in the days following John O'Keefe's death. Cellbrite software was used by the Commonwealth and the defendant's expert to interpret the digital data. Cellbrite extraction reports are computer-generated records, and do not implicate the rule against the hearsay. In Mr. Whiffen's expert reports provided to the defendant in 2023 and 2024, Mr. Whiffen utilized his superior knowledge of Cellbrite software to demonstrate how, where, and when Jennifer McCabe's Google searches. See, where, when, how. Well, I want to talk about location of Jennifer McCabe. Where was the cell phone located? Was it on the first floor or was it on the second floor? The Commonwealth moves to permit Mr. Whiffen's Mr. Whiffen to conduct a demonstrative using Cellbrite software to enable the jury to better understand the digital forensics. It is within the sound discretion of the trial judge to permit a courtroom experiment, demonstration, or reenactment. It's going to be boring as fuck. The Commonwealth intends to have Mr. Whiffen use the highly disputed extraction report from Jennifer McCabe's cell phone to demonstrate with Cellbrite software how, where, and when the digital data of the Google searches were stored. So they want to talk about where they're stored, right? This demonstration would closely mirror the actual Google searches conducted by Jennifer McCabe on January 29, 2022, and would aid the jury in understanding how Mr. Whiffen is able to opine that the contested searches occurred at approximately 6:24 a.m. and not 2:27 a.m. But what you need to ask him is, okay, it doesn't tell you who's using the phone, right? Who's the user, right? Did you look at the location data on that? Did you know there was a watch that she was wearing? Okay. So did you look at the flights, the stairs, or did you just look at, were you just doing, because Cellbrite is the extraction report of it. So you got the whole caboodle. You got all the page, that's everything. So how reliable is it that the Apple Health data, when it was downloaded to show that the phone is not going up flights of stairs like the watch is, but the watch and the phone are supposed to be together with the same human? What do you got for that? You guys, if you put Matt with the phone and you ask Matt what he does for a living, because these people are going to be testifying that you have to know what you're doing. If you know what you're doing, you can manipulate things, right? The jury's not going to believe that Jennifer McCabe would know how to do any of that. But Matt McCabe and what he does for a living? Lay witness testimony that a black article of clothing could appear light colored when viewed at night using the type of surveillance system. Yeah, this is what's going on in the Colbert case right now. People think that the car is black, and it's like, no, it's white. It's the lighting. But the jury doesn't understand that. Let the jury think that. But the judge's understandable concern that without the jury hearing such testimony, they might as well have applied a skewed view of the strength of the exculpatory value of the surveillance video. Exactly. So notably, the defendant does not dispute the reliability of the Cellbrite software, and her own expert has relied on the Cellbrite to draw their conclusions. In addition, both Ian and Hyde would use demonstratives to aid and to articulate and to explain important data information contained on both Jennifer and Johns. What are you going to talk about on Johns? What are you going to talk about on Johns? It's going to be interesting. Commonwealth motion in limine to admit the victim's out-of-court statements relating to his state of mind. And this, hold on, is this where I wanted to leave off? I wanted to end on this one. We're going to end with a boom because it's Proctor Day. So Proctor, here it is, defendant's motion in limine to exclude false and irrelevant statements of Michael Proctor. Now comes the defendant, Karen Reed, and respectfully moves this honorable court in limine to exclude any reference at trial to false personal accusations made by State Trooper Michael Proctor against attorney David R. Yannetti, included but not limited to Trooper Proctor's false allegations that Mr. Yannetti purportedly parked in the parking lot of a school in order to harass Trooper Proctor's sister, Courtney Proctor. During the first trial of this matter, Trooper Proctor's falsely claimed that when Mr. Yannetti had gone to the parking lot of a school where Courtney Proctor was allegedly employed, he, 1, refused to leave the school parking lot when confronted by a teacher, and 2, upon being confronted by a teacher, he asked about Courtney Proctor's whereabouts and asked whether she worked at the school. June 12, 2024. Both assertions are false, as demonstrated by the police report of Canton Police Officer Eric Katovich, dated June 12, 2024, attached here to as Exhibit A. See also the affidavit of David R. Yannetti. Motion 600 is a boom. Lana, they just dropped motion 600. Let me take a look. Let's see. Boom. Everything's a boom. Let's see what we got here. I don't have it. Oh, let's see. Go ahead and take a look at that. Is Marcus still in chat? Oh, yeah, that's coming up. Oh, that one right there. Oh, let's see. Oh, just got it. The defendant's motion for reconsideration of March 6, 2025, court order denying defendant's motion to exclude the testimony of the Commonwealth's witness, James W. Crosby, 601. Damn. They're just firing at all cylinders, guys. They're just firing at all cylinders. We'll print that out here. But I think it's great. I think Proctor and his sister have a real close relationship, if you know what I mean. Jeez. Trooper Proctor will be testifying in court or in trial too. The question is what is going to be allowed to be talked about? Like, hey, you lost your job. Hey, you're no longer with that. You know what I mean? Like, this is wild. Are we going to even have a resolution at that point to know what? I don't know. What's 602? I'm just curious what they dropped for 602. Anyways, you guys, on June 10th, Juror Proctor testified as a witness for the Commonwealth in Miss Reed's first trial. On direct examination, he testified that while the investigation of Miss Reed was ongoing, he sent text messages to other members of the Massachusetts State Police about Attorney David Unetti, saying, "I hate that man. I truly hate that man," end quote. On redirect, which occurred on June 12th, Juror Proctor was asked to clarify why he disliked Mr. Unetti. During his response, Trooper Proctor falsely claimed that Mr. Unetti had gone to the parking lot of a school where Trooper Proctor's sister worked the day before in order to harass her. You guys, this trial has become literally it is little kids. Like, it's like growing up and you're like, oh my God, that little fucking liar. You know what I mean? That little liar. Like, this is insane. I hate that man. I truly hate that man. Trooper Proctor falsely claimed, apparently referencing rank and false hearsay, as Trooper Proctor did not claim to have been present when Mr. Unetti was there. That Mr. Unetti had been asked to leave the parking lot but refused. Trooper Proctor also falsely alleged that Mr. Unetti asked someone at the school if Michael Proctor's sister was working there that day. He testified that Courtney thought she was being served, although there was no evidence that Courtney Proctor ever saw Miss Unetti that day. At this point in the testimony, defense counsel objected, and the court requested that counsel approach a sidebar. After consulting with counsel, the court correctly concluded that Trooper Proctor's testimony regarding Mr. Unetti should be stricken from the record, and the jury to disregard the testimony. After the trial ended in a mistrial, defense counsel received a copy of a Canton police incident report that was filed in relation to Mr. Unetti's presence at the school parking lot. The incident report directly contradicts every false allegation from Trooper Proctor's testimony on June 12, 2024, and shows that Trooper Proctor made completely false statements under oath. The incident report states that the principal of JFK Elementary School contacted Patrolman Eric Kasevich, the school resource officer, to make him aware that Mr. Unetti and Brian Lochran had been seen in the school parking lot that day. See Exhibit A. The principal informed Patrolman Kasevich that Mr. Unetti and Mr. Lochran were, quote-unquote, not approaching the school, students, or staff, and that she only wanted to make Patrolman aware, quote-unquote, in the event that things escalated or hit social media, end quote. Patrolman Kasevich responded to the school and spoke to the principal and others at the school. He detailed that, in quotes, it was reported that neither individual ever approached the school, students, or staff members, end quote. Patrolman observed Mr. Unetti, Mr. Lochran, and two individuals pull into the parking lot, talk for 5 to 10 minutes, and leave the parking lot in their separate cars. Patrolman Kasevich wrote that, quote-unquote, none of the four ever pointed at or approached the school staff or students. Trooper Proctor's claims that Mr. Unetti was asked to leave, refused to leave, and inquired about Courtney Proctor were all completely fabricated. What a fucking dumbass. I mean, I want to see Unetti sue the fuck out of him. Sue this fuck? Unetti, sue him. What the hell is he, what is going on in this world? Take one out of Turtle Boy's book and sue the motherfucker. Put this guy on blast. This is nuts. Trooper Proctor should be disallowed from making these types of inflammatory accusations against Mr. Unetti at Ms. Reed's retrial. Any evidence related to Mr. Unetti's, I want to say this notably, the report was not provided to the defense during trial when the defense could have used the information to further impeach Trooper Proctor's credibility. Fucking sue him. Just sue everybody. Mr. Unetti harassed. I can't even believe this. I cannot believe this. Evidence of David Unetti's presence in the school parking lot lacks any probative value and is therefore inadmissible. The proffered false allegations is inflammatory and prejudicial and is therefore inadmissible. You know what? Could this have been something that affected, because he met with Lucky? Could have been something that affected the jury from listening to Lucky then? You know? This is bullshit. These people make me sick. What occurred in a desperate attempt to take attention away from his egregious conduct in conducting and manipulating this investigation to get the result he sought? Justice be damned. Oh my God. I love it. To get the justice be damned. Give me a t-shirt, man. Woohoo! Justice be damned. I mean, this is wild, you guys. The defense has its suspicious about which explains makes the most. Wait, what? I think I was supposed to say suspicions about which explanation makes the most sense. But whatever the reason, his testimony was false, misleading, and speaks poorly of Trooper Proctor's ethics and investigatory skills. Good, get him where it hurts, you fucking cocksucker. God, you do suck. If allowed to testify at the retrial about this fictitious interpretation of what occurred in that parking lot on June 11th, 2024, there would arise a significant danger that admission of the evidence would unfairly prejudice Ms. Reed. I want to see this part again. Through his testimony, Trooper Proctor essentially and clearly, falsely, accused Mr. Unetti of purposefully harassing Courtney Proctor at her place of work. This accusation is inflammatory, which is likely the reason that Trooper Proctor unethically injected it into the trial in the first place, and could lead the jury to harbor some animosity against Ms. Reed based on their emotions towards Mr. Unetti and the defense team, rather than focusing on relevant and material evidence. It could also fuck with Lucky. Additionally, Trooper Proctor's accusations are baseless and false, making their admissions even more unfairly prejudicial to Ms. Reed. Given Trooper Proctor's lack of firsthand knowledge regarding a false allegation that he purposely and recklessly tried to put in front of a jury, there are only three explanations for his testimony. One, someone lied to him about what occurred in that parking lot on June 11th, and he testified to it without doing any further investigation to find out if it was true. Two, Trooper Proctor somehow misunderstood what was being told to him and never sought to clarify that information before testifying to it under oath. Three, Trooper Proctor blatantly lied. blatantly lied about what occurred in a desperate attempt to take attention away from his egregious conduct in conducting and manipulating this investigation to get the results he sought. Justice be damned! Guys. The defense has its suspicion, but you guys can decide. This is sick. God. Oh, poor Courtney Proctor. Poor Courtney. Poor everybody. All right, so what came down in the 601, guys, is the defendant's motion for reconsideration of the March 6, 2025 court order denying defendant's motion to exclude the testimony of the Commonwealth's witness, James W. Crosby's. I'm going to read it first, take a look, but yeah. Here's the Commonwealth's, they're saying that they want this to be admitted, the Good Samaritan Hospital results. So that's where we'll leave off. Join me back tomorrow morning. This is crazy. This is crazy. Michael Proctor. Fucking loser. Peace out. Join me back here at the 11 o'clock hour. Got some bombs over there in Culver. We officially have what the state wants to say and how they want to say it to explain how they got to Brian Koberger. So it's officially in, and it's officially wild this month. But free Karen Reed. She sucks. Go fuck yourself. Peace out. Thank you, moderators. Appreciate you. Join me back tomorrow morning for more Karen Reed. Just hitting them all up so that we can be ready for this trial 2.0, motion limines, all those good things that are coming up here in the next couple weeks. Trial should be lit as a tit. It's like going to be watching General Hospital, so tune in.